On Monday, I sent a letter to Alberta Justice requesting a review of a decision by the Alberta Crown Prosecution Service. This is the first time that EPS has overtly sought to have the ADM review a file to potentially intervene and rescind a plea agreement. It was a step that was taken only after our officers repeatedly spoke to the Crown on this file, including when charges were first laid. In short, this is not the first straw. This case matters, and I want to talk briefly about the case now. As we stated, we worked with the Crown when we first laid first-degree murder charges in this case. And while we understand that the Crown has to present the case, there was no consultation with lead investigators or the EPS about the reduction of these charges. In mid-April, our investigators were made aware by happenstance of the prospective plea deal. This was despite close collaboration with the Crown through the investigative process. The shock we all felt in learning this news against what we knew of the case was significant. At no time has anyone from the Crown suggested that there are deficiencies in the file that would justify this path. The step we took on Monday, directly seeking to have the ADM and her superiors review the file to intervene in this process, was an extraordinary step. But it was a legitimate path for the ADM to intervene, and if ever there was a case that we believe should have made her do so, this was it. I understand that the following facts were admitted about what happened to this child. The offender admitted to causing some of the prior injuries on the 8-year-old child. The court heard a significant list of recent and historical injuries that the child had suffered. The circumstances depicting a hole in the wall, a severely injured child laying in her blood, with blood coming from her mouth, were described without conclusion about what caused the injuries. The offender admitted she was aware of the injuries that the child had. She knew that medical treatment was required for those injuries. She failed to provide this medical treatment, and this caused the child's death. The offender did not seek treatment for the child and was more concerned about what to do with her body. Police reached out to the offender to do a welfare check, and she stated all the kids were fine and that the child had been picked up by her biological mother. Even this statement of fact only scratches the surface of the horrific circumstances of this offense, and nothing we heard today has changed how we see this file. This 8-year-old child was failed so many times in her life. Her case remains one of the most horrifying cases of child abuse and ultimate death from abuse that our police service has ever seen.